How to defend if you are accused in check bounce case and during the trial the complainant filed an application under section 143A of Negotiable Instrument Act for interim compensation. यदि किसी चेक बाउंस के मामले में आप आरोपी हैं और शिकायतकर्ता ने कोर्ट प्रोसीडिंग्स के दौरान अंतरिम मुआवजे के लिए धारा 143A के तहत आवेदन दायर किया है, तो आपका बचाव क्या होना चाहिए? चेक बाउंस केस, दैट इज कंप्लेंट केस अंडर सेक्शन 138 ऑफ नेगोशिएबल इंस्ट्रूमेंट एक्ट में बहुत सारे केसेस ऐसे भी होते हैं जहां कंप्लेनेंट ने चेक का दुरुपयोग कर यानी मिसयूज करके एक झूठा और मनगढ़ंत केस फाइल किया है, या जितने का लेन देन नहीं है उससे अधिक अमाउंट चेक में भरकर केस फाइल कर दिया है. There are many cases where the complainant misused the check and filed a false and fabricated case under section 138 of Negotiable Instrument Act. तो ऐसे केसों में आप एक्यूटल कैसे होंगे यानी बरी कैसे होंगे, यह आपके डिफेंस, आपके एविडेंस और क्रॉस एग्जामिनेशन पर डिपेंड करता है. आज हम इस पर चर्चा नहीं कर रहे हैं. Today we are discussing only if the complainant during the trial filed an application under section 143A of Negotiable Instrument Act for interim compensation. Then how will you defend? First, we would like to know about the section 143A of Negotiable Instrument Act. Section 143A was introduced in the Negotiable Instrument Act via Negotiable Instrument Amendment Act 2018, and it came into effect from 1st September 2018. Section 143A gives the power to the court to direct the accused to pay interim compensation to the complainant, which shall not be exceed 20% of the amount of the check. धारा 143A को नेगोशिएबल इंस्ट्रूमेंट अमेंडमेंट एक्ट 2018 के द्वारा जोड़ा गया और यह 1 सितंबर 2018 से प्रभाव में आ गई. धारा 143A के तहत कोर्ट आरोपी को निर्देश दे सकता है कि वो शिकायतकर्ता को अंतरिम मुआवजा प्रदान करे जो कि चेक अमाउंट के 20% से अधिक नहीं हो सकता. नाउ द क्वेश्चन arises whether the section 143A of Negotiable Instrument Act is retrospective in the and can be invoked where the offence punishable under section 138 of Negotiable Instrument Act committed much prior to the introduction of section 143A. It cleared by the Honorable Supreme Court in case G.J. Raja versus Tejraj Surana in 2019 and cleared that section 143A is prospective in operation and that the provision of section 143A can be applied or invoked only in cases where the offence punishable under section 138 of the Negotiable Instrument Act were committed on or after the 1st September 2018. अतः ऑनरेबल सुप्रीम कोर्ट ने केस टाइटल G.J. राजा वर्सेस तेजराज सुराना 2019 क्लियर कर दिया कि धारा 143A के उपबंध भविष्यलक्षी होगा और मात्र उन प्रकरणों में लागू होगा जिनमें बाद कारण उक्त उपबंध के लागू होने के दिनांक 1 सितंबर 2018 को या उसके उपरांत उत्पन्न हुआ है. Now, if the complainant filed an application under section 143A of Negotiable Instrument Act, then how to file the reply of this application and what will be the ground of the reply कर्ता ने धारा 143A के तहत आवेदन दायर किया है, तो आप इसका रिप्लाई कैसे फाइल करेंगे और उस रिप्लाई में क्या ग्राउंड होने चाहिए. अब हम रिप्लाई पर आते हैं. यदि शिकायतकर्ता ने धारा 143A के तहत आवेदन फाइल किया है तो आप इसका रिप्लाई कैसे फाइल करेंगे या आपके रिप्लाई में क्या ग्राउंड होने चाहिए. फर्स्ट, नाउ आई एम टेलिंग द ग्राउंड ऑफ योर रिप्लाई ऑफ द एप्लीकेशन अंडर सेक्शन 143A. फर्स्ट, आप इनमें से अपने केस के अकॉर्डिंग ग्राउंड रिप्लाई में लिख सकते हैं. फर्स्ट ग्राउंड, द अक्यूज्ड हैड नॉट इशूड द सेड चेक फॉर डिस्चार्ज ऑफ एनी लायबिलिटी. Second ground, the accused neither requested nor received any amount from the complainant as alleged. Third, there were no written agreement or any promissory note between the parties. Fourth, the complainant misused the blank security check and there is nothing, any amount due against the accused. Next, the complainant concocted a false and fabricated story and there is no relation between the complainant and the accused never taken any loan from the complainant. Next, the provision of section 143A of Negotiable Instrument Act is not mandatory and it discretionary. The provision of section 143A is not mandatory, it is directory. Therefore, it is not necessary in every case to grant 20% of the check amount as interim compensation. The legislature has used the word may in this provision and this is discretionary and the court should not have granted 20% of the check amount as interim compensation in every case. The provision of section 143A is discretionary and not mandatory and discretion must be exercised on case to case basis on examination of the fact of each case. The said check were issued as a security check and the accused has settled the account with the complainant and there is no legally enforceable debt. The accused has not caused any delay in the court proceedings as the accused and his counsel is appearing each and every day and cooperating the proceedings and there not any unnecessary delay or adjournment sought on behalf of the accused. Next, the accused is entitled to raise a probable defense that there is no legally enforceable debt or liability against him. The accused is entitled to lead the evidence and cross-examine the complainant to test the veracity of the case of the complainant. The court exercised the discretion vested in it under section 143A of Negotiable Instrument on judicially on consideration of the facts and circumstances of the case and strength of the defense of the accused. As per observation of the different honorable high courts by several judgments, it cleared that the section 143A of the Negotiable Instrument Act is not mandatory and is directory and it is discretionary. Here we would like to discuss about the some judgments of the honorable high courts which says that the provision of section 143A is not mandatory and is discretionary only. और इन जजमेंट्स को आप रिप्लाई भी मेंशन कर सकते हैं और रिप्लाई के साथ इनको फाइल भी कर सकते हैं. मैं इन जजमेंट्स को आपको पढ़ के बताता हूं. The Honorable Delhi High Court ruled in case JSB Cargo and Freights Forwarder Private Limited and others versus State and others, criminal miscellaneous petition number 2663/2021 decided on 26 November 2021 held that Honorable Delhi High Court in case title JSB Cargo and Freight Forwarder Private Limited and others versus State and others, criminal miscellaneous petition number 2663/2021 decided on 26 November 2021 held that it became apparent that the provision of section 143A of the Negotiable Instrument Act has essentially to be held to be directory and cannot be turned to be mandatory. The next judgment, the Honorable High Court of Karnataka in criminal petition number 524/2022, case title Padmanabha TG versus Messrs Radical Works Private Limited held that Padmanava TG versus Messrs Radical Works Private Limited held that the conduct of the accused would be the driving force for the granting an interim compensation under section 143A of the Negotiable Instrument Act, and such reasons should be recorded in the order. Next judgment. The Honorable High Court of Bombay in criminal writ petition number 48/2022 in case title Mr. Ashok Rao Karokar versus Mr. Lakshmikant Govind Joshi. Title Mr. Ashok Rao Karokar versus Mr. Lakshmikant Govind Joshi with criminal petition number 71/2022 in case title Mr. Ashok Rao Karokar versus Mr. Lakshmikant Govind Joshi. Judgment dated 7th July 2022. The Honorable Court answered the two questions. First answer, the provision of section 143A of Negotiable Instrument Act are directory and not mandatory. Second, the court has to record reason for determining the quantum of the interim compensation if it comes to the conclusion based upon the fact position availing that it is a court which deserve award of interim compensation which can be anywhere up to 20% of the check amount. The court has to record the reason for determining the quantum of the interim compensation. The court has to record the reason for determining the quantum of the interim compensation. Next judgment, the Honorable High Court of Jammu and Kashmir and Ladakh. Judgment dated 23rd December 2022. Criminal petition number 50/2020 in case title Nazir Ahmed Chaupan versus Abdul Rahman Chaupan held that a bare perusal of the aforesaid provision makes it clear that a court trying a complaint for offence under section 138 of Negotiable Instrument Act has discretion to order the drawer of the check to pay interim compensation to the complainant, or this amount of the complainant has not be exceed 20% of the amount of the check. The grant of the interim compensation is a discretionary power which has to be exercised by a magistrate trying a complaint under section 138 of Negotiable Instrument Act, and order has to be based on reason and logic. Next judgment, the Honorable High Court of Karnataka on 31st March 2022 in criminal petition number 1550 of 2022 in case Sri Narayanaswamy versus Sri Ramesh JS in case title Sri Narayanaswamy versus Sri Ramesh JS. The learned magistrate will have to exercise his discretion in terms of section 143A of the Negotiable Instrument Act, taking into consideration the application. इन जजमेंट्स का जिक्र आप अपने रिप्लाई में कर सकते हैं और इन जजमेंट्स को आप अपने रिप्लाई के साथ फाइल भी कर सकते हैं। और यदि ट्रायल कोर्ट ने आपके अगेंस्ट इंटरिम कंपनसेशन के ऑर्डर कर दिए हैं तो आप इसको चैलेंज कर सकते हैं क्रिमिनल रिवीजन पिटीशन के द्वारा एडिशनल सेशन जज के यहाँ। और यदि एडिशनल सेशन जज ने आपकी क्रिमिनल रिवीजन पिटीशन को रिजेक्ट कर दिया है तो आप इसको चैलेंज कर सकते हैं बिफोर ऑनरेबल हाई कोर्ट थ्रू क्रिमिनल मिसलेनियस पिटीशन अंडर सेक्शन 482 CRPC के तहत।